Hello, Lyric Armstrong, your real estate agent and advocate. I was working on the last video. We just looked at our in-camera review video relative to Judge Glanville transferring the case. Go check that out. There's some details, lots of details, but actually some indication as to what the judge believes was pertinent and non-pertinent relative to the motion for recusal, but the facts to be decided upon by a different judge nonetheless. However, in doing that, I came across a video that happened a couple days ago. So sorry, I have been so involved in other trials, namely Karen Reed, which finally came down to mistrial today, where I didn't see this hearing going forth, but would like to just take a little peekaboo at this. Looks like this is YSL defendants rejecting plea offers, I believe, outside of the Young Thug Trial. So I believe these are the other defendants, because remember, there's 28 defendants all together. So let's see what's going on here.
Garlington. Good morning, Judge Thomas Mondelli for Mr. Garlington. On this case, Your Honor, the state conveyed an offer in writing, which I've conveyed to my client. I've spoken with the state as well. At this point in time, we are declining their offer. The case will be further noticed as a result, but per discussions with the state, we would like to be able to keep negotiations open.
And today is the last opportunity to make a negotiated plea. Anything after the debate is going to be non-negotiated, regardless of whether the state or the defendant has negotiated something. We put this on the calendar a good while back. This case has been going on since God created Adam. And so if you haven't worked out something yet, too tough. We just moving it to the trial calendar. And that's all I've got to say. So you had plenty of time to talk about what could be done, and that's it. So further notice to the trial calendar, state's offer is withdrawn. Anything after this is.
And so that helps you to realize that this is the other defendants. One, I don't recognize them visually, but even if I did, because there's so many of them, I probably wouldn't recognize them visually anyway. But also because he's talking about moving on to the trial calendar, putting this on trial. So this is pre-trial. Are you taking the plea offers? And this defendant says, no, we reject.
Non-negotiated.
That's fine, Judge. Thank you.
You're welcome.
Now this young lady comes up and says something interesting.
How to open your car door while submerged underwater.
Okay. So she has to say.
State versus Adams. Non-negotiated.
That's fine, Judge. Thank you.
You're welcome. State versus Adams. We'll do a pretrial. Come back to you. All right.
Judge.
Yes.
Let me make sure everyone is on the mic.
I'm sorry.
Let me make sure that all speakers are on the mic or at a mic.
Okay.
Right.
Were you able to get the last statements?
No.
Ms. Jones, were you able to get the last statements?
Yeah, she was very low, but I did hear her. I just want to make sure.
All right, folks, on the Zoom, and you'll need to be at a microphone that's actually working. I think that one might not have been working. Is it?
The microphone actually working? Non-working microphone?
All right.
Oh, I thought they just want to press the button.
No, Ms. Jones said it was difficult to hear, but she got it. So All right,
Ms. Jones,
Simone
I
Blaylock.
don't hear him. Go ahead, Ms. Jones.
Good morning, Your Honor.
Good morning.
We received an offer from the state. I have reviewed that with Mr. Blaylock. At the moment, he would like to reject that offer, and we'd be asked to please be further notice for a trial calendar. I'm sorry.
Go ahead.
There was one other thing that I wanted to just discuss with you. As I notified the court that I had filed a motion in reference to Mr. Blaylock's severance from the original trial. An order on that motion was filed on May 10th, if I'm not mistaken. I did request a hearing on that motion. I never received notice of that order until June 11th. I filed a motion requesting that the Honorable Court please reconsider that motion and allow me to be heard on that motion. There were some things that I did want to bring to the Honorable Court's attention to at least put on the record. So I would respectfully ask the Honorable Court if we could please set that for a date, and I could be heard on that motion. Yeah.
Okay, no, that I decided it based on the brief. The defendant cited no authority for the proposition that the court was required to have a hearing on the motion. And so the facts and the circumstances that on the transcript from the proceeding were clear, and therefore there was no merit to going back to allow defense counsel to be able to orally argue a meritless motion. Second thing, we filed it in Odyssey. And from what I understand, your information is correct. So that's what we're supposed to do, file it, and it's supposed to go to counsel. Well, I don't know why you didn't get it, if in fact you didn't get it. But the more significant is the fact that Ms. Chavis, the case manager, emailed you a copy, and you didn't file a motion until 11 days or thereabouts after you actually clearly had notice of it because you got sent to you. And then the Superior Court rules, if you want to make a motion for reconsideration, you got to do it within 10 days. So even if you didn't get it under the normal Odyssey process, you had more than 10 days before you filed the response. So it was untimely. But, you know, this is, with apologies to the four tops, this is just the same old song, and it wasn't good the first time. So with no disrespect intended, I'm not going to just take up court time to allow somebody to come in to argue a case when the pleadings clearly make and the facts aren't really in dispute. Therefore, that motion for reconsideration is denied.
Okay, Your Honor. I
You further notice into the trial calendar, correct?
Yes, Your Honor. I just put just a few things on the record just for purposes of Mr. Blaylock.
Yeah, go ahead.
Just as it pertains to that motion, I did want to say, so again, that Mr. Blaylock did not consent to his severance originally.
Which is in the original brief.
Yes, correct. So generally, the trial court is allowed to sever an individual if upon a motion by the defense or the state that it could be granted on that basis. A motion to sever was heard on behalf of all the defendants in this case earlier, which was denied. On this particular day, neither Mr. Blaylock nor the state raised a motion. Both of us actually opposed. Mr. Blaylock and the state opposed that motion. There was no finding of manifest necessity by the court. There was no facts that the Honorable Judge Glanville laid out to indicate manifest necessity on this particular day. The only information that
Oh my gosh, this is so comfortable.
We don't have time to edit this, so these little commercials are disturbing.
manifest necessity on this particular day, the only information that Judge Glanville put was that it served his best interest. To be quite frank, I'm pretty sure it would serve everyone's best interest to be severed in this case. However, there were no factual findings of manifest necessity, which is what is required for a trial judge to sever a defendant. There was no facts. There was nothing pertaining to the actual evidence in the case that was laid out as to justifying Mr. Blaylock's severance. It was simply that he fell ill one day. He wanted medical treatment. Mr. Blaylock and I offered to waive his presence, offered an alternative to being severed. The Honorable Court denied that and elected to sever him despite his discontent with that. And just ultimately, there were no factual findings. There were no findings based on the evidence being confusing, being prejudicial to Mr. Blaylock, and no finding of manifest necessity by the court justifying his severance without his consent. That's all I have to say on that, Your Honor.
Question, what if anything you just said now that you didn't put in the initial brief?
I put most of that in the initial brief. Just the reasons that people generally have motions. I'm sure that when we come in here and I'm able to.
So what the judge is saying, you just wasted my time. I've already put in the order based upon the brief. And the brief is the actual motion, the written document that he put forth. Another problem was he wanted to be heard on the motion. So to be heard on the motion, you have to request it and you have to present the authority that supports such request. And so he requested it, but he didn't put the authority. Authority would be any parts of the law that supports that, whether it's a different case law, a code, a statute, whatever the factors you would use to support it. So just like I said in some other videos, your P's and A's, you make a point and you put the authority behind it. This is the same thing, making a request and then you put the authority behind it to support such request. Not done in the judge's view. This is not Judge Glanville, this is someone else. And consequently, he's saying, you know, what's the purpose of the hearing that you want? Because a hearing is to not go outside of the motion, but to give more context. You might then give some relatives. This is when you might say, this is in relation to something different. This is how we come to, you know, an understanding. Common sense would bring us to this place. It's obvious this, it's obvious that. Certain things you just wouldn't put in a motion that are like colloquialisms or general conversation. Motions are mostly based upon points and then what the law says. And then you'll go into a hearing and you'll speak to what is best for the community, what's best for the client, why this is best for all persons involved, saving funds for the community to not have to spend extra tax dollars by severing his case out. Severing means that his case is going to be separate from the rest of these individuals that are cited together. So this attorney is asserting that his client does not want his case parceled out. Interesting enough, a lot of times people like to go separate. So, but he doesn't want to go separate. He wants to go with everyone. And this attorney is asserting that the Chief Judge Glanville, who made that decision to sever his case, in fact, did so just because he was sick, when actually they just wanted a waiver for him not to be present during a hearing. It's important for the defendant in a criminal trial, especially, to be present at all times, because things that are happening, the defendant can say, wait, attorney, that's a lie. That was so-and-so did that, or ask him about this, or what about that? Did she do this? Isn't she the, you know, doesn't she have a reason to lie? Because I know this about her. And so consequently, you want to be there because everything can be critical and material to your defense. And the judge wants to ensure that you're there to witness everything going on so that you later don't put up appeal that it was somehow unfair to you because you weren't allowed to be there. And so I guess he was ill. And so since he was sick, he ended up getting cut from, you know, severed from the original case that they're talking about. And he's going to be put onto his own case. And this attorney is arguing he doesn't want that. And the judge is like, so what?
To orally express certain things to you, I'm sure that I can not only have a chance to respond to what the state says, but also I can answer any questions that you may have, frame things in a different way, rather than taking up paper, putting everything in a written brief. So that's really why I wanted to be heard, just to, you know, really be able to flesh out some things and answer any questions that you may have. If the Honorable Court stands by his ruling, I completely understand and I respect that. But I did just at least want to be able to put some things on the record.
Okay, well, let the record reflect, you just argued the motion and you haven't said anything that's going to change the court's mind. And so the motion is denied. All right.
Okay, Your Honor. Thank you. May we be excused?
Yes, sir, you can. We've got so many defendants in here, we'll have to, in an orderly fashion, allow different defendants to be excused at the time that is most convenient and safe for the sheriff to handle that. So, but you may be excused. So have a good day.
You too, Your Honor.
Who is your attorney, sir?
He doesn't know.
Oh, Mr. Lalum. Okay. All right. Yes, sir. I think we received an email from Mr. Lumumba, was it yesterday sometime or whatever, indicating that he had a family emergency and needed to be at the hospital with his father, was what we were told. I think the state was actually sent a copy of that email as well. Ms. Hilton?
Yes, Your Honor. Looks like, are you here?
I am, Your Honor. My name is Attorney Frank Passion. I've been the
Would you get on the microphone for us, sir? And would you come on, man. You know, I'm trying to do the best we can to. Yeah. All right. That's fine.
That's horrible. I can't hear him talking to the mic. What? He must be snapping because he doesn't know this guy. And this guy is going to stand in for his normal attorney because his normal attorney has a family emergency. And so he must, I don't know what he's saying, but he's obviously saying something disgruntled or inappropriate. The judge is reprimanding him and saying, stop it.
Are you here?
I am, Your Honor. My name is Attorney Frank Passion. I've been the
Would you get on the microphone for us, sir? And would you come on, man. You know, I'm trying to do the best we can to. Yeah. All right. That's fine. We will see what's what. All right. All right.
Mm-hmm.
Yes, sir.
morning, Judge. As I was saying,
I wonder if Miss Jones has gotten everything he said, because I didn't hear a thing.
my name is Attorney Kareem Pashlin. I'm the newly appointed attorney for Mr. Cobb.
This is Mr. Cobb.
This is Mr. Fleetwood.
Well, that's half the issue.
Ms. Jones, did you get counsel's name? So I can have him spell it for you if you need to.
So I see, I apologize.
Your Honor, it appears that Mr. Luemba is the attorney on positions number 5 and number 8, who would have been Justin Cobb. And so it appears that.
Okay. So somebody was making a whole lot of fetch about it. I don't know who it was, but this is how it came to me. Oh, the attorney doesn't even know who he's there to represent. He does know who he's there to represent. He's there to represent Mr. Cobb. And as you can see, 88 Hilton is in the building. And so it gets to a point where this other gentleman, Mr. Fleetwood, who's another defendant that is represented by the same attorney, Lumen or Luma, I think it's Luma. He represents Mr. Cobb and he represents Mr. Fleetwood. Mr. Fleetwood has seen one attorney has left, so he's like, Judge, where my attorney's not here, I don't see my attorney, I don't understand. And the judge is like, oh, who's your attorney? Lumen? Okay, Luma, he received an email from him letting him know he had an emergency. So he's sending over representation in his stead. Consequently, 88 Hilton offers, yeah, this gentleman's here to cover for him. Well, that gentleman was there to cover for one client, which was Mr. Cobb, I guess. So that's where the kerfuffle comes about. And she goes to explain. So let's see what the full explanation is. Now that we have some understanding as to why that attorney was confused. He wasn't confused about his client. And that's the way the news put it. Oh, he's confused about who his client is. They've never met. So he doesn't know what the man looks like. And he walks up and says, I'm here to represent Mr. Cobb. And it turns out Mr. Fleetwood is also one of the defendants, but he's new to the case. He's not even new to the case. He's standing in for Luma, and that doesn't mean that he's taking over.
who would have been Justin Cobb. And so it appears that Ms. Cobb, okay.
Ms. Jones, did you get counsel's name? So I can have him spell it for you if you need to.
So I see, I apologize.
It appears that Mr. Luemba is the attorney on positions number 5 and number 8, who would have been Justin Cobb. And so it appears that Ms. Cobb, okay. Sorry.
Okay, well, we haven't got to him yet, so you can have your seat, okay? All right.
So all of that, he doesn't know who he represents. It was ADA Hilton who says, oh yeah, well, that is Luemba's client. And the guy goes, oh, I'm here to cover Luemba. And so she's like, yeah, he's here to cover Luemba, but it's only for one of his clients, not really realizing it's a couple of clients, and the one who was speaking out is not the particular one. So that was much to do about nothing.
Your attorney that's assigned to you, now whether or not y'all have had any in-depth discussions or all of those kinds of things, I hear what you're saying, and you're indicating that you don't even know who they are, and I appreciate what you're saying, all right? He isn't here today, so we will deal with that as appropriate. Let me say this in response to what you just raised, sir, as well as in general. Anyone that's paid any attention to what's been going on in the state of Georgia and Fulton County understands that there's a lack of attorneys available to handle these types of cases. It takes forever for the whatever the name of that organization is.
I'm sorry. So we have an excuse for why we don't know who our clients are, and the client should be more patient. So then why do we have to accept or deny the plea deal right now if we haven't even talked to our attorney? How are we mandating that the client needs to accept, or the proposed defendant needs to accept or deny the plea deal on today? This is the last time that they get to do that, and they haven't even had a chance to talk to a defense attorney to determine if they have a defendable case. I got time. You want to tell me, Your Honor? You care to make this plain and interesting enough that we can make sense out of chastising the defendant as if the defendant is in control of the attorney assignment? We're going to chastise the defendant because the defendant doesn't have the ability to accept or deny the plea deal because they haven't had a chance to talk with their attorney to even understand their plea deal and their position if they go to trial.
These types of cases, it takes forever for the whatever the name of that organization is. That I never can get these initial kinds of things straight, but when a request is made for an attorney to be appointed to represent a defendant, it takes forever for them to get somebody and put them in place, which means that it does take time for the attorney to come up to speed and to actually be able to communicate with their clients in order to properly prepare to handle a particular cases. This case has been going on so long that certain defendants may have had one attorney, then somebody left the PD's office, or somebody left the Georgia, whatever they call them, Counsel of Defense Lawyers or whatever it is. And then somebody else has to be appointed and then come up to speed and all of those kinds of things. Well, that's what we're dealing with. So what we do is the best we can do. So if somebody hadn't had a chance to adequately prepare or they aren't properly representing their client, then we do what we need to do to make sure that that doesn't affect the ultimate result of the case. So he's not here today because he has a legitimate emergency. Now, whether or not he's talked with you, met with you, or prepared with you previously, I can't deal with that, and I have no reason to doubt what you're saying. But as far as what we can do today, his father apparently is in the hospital, and unless we've been told something that's not true, and I don't have any reason to believe it's not true. His father's in the hospital in a very serious situation, and he's there with his attorney there. We'll look further into the idea of whether or not he's adequately been prepared or been with you to do what he needs to do to represent you in this particular case. So that's the best I can tell you right now. Now, if you want to, you may want to hear what the rest of what's going on. If you would, you can stay. If you want to step out, then we can do that now if the sheriff is able to do that. Okay.
Oh, I got distracted.
To do that, stay. If you want to step out, you may. I can tell you right now.
That's the best I can tell you right now.
He's adequately been prepared or been with further in the hospital in a very serious situation. And he's there with his attorney there. We'll look further into the idea of whether or not he's adequately been prepared or been with you to do what he needs to do to represent you in this particular case.
What's it to do
So
with him accepting
that's the best
his
I can tell you right now.
So,
Now, if you
what
want
about his detail?
you may want to hear what the rest of what's going on. If you would, you can stay. If you want to step out, then we can do that now if the sheriff is able to do that. Okay.
I don't think that Rusty would be here today if it wasn't for the farmer's dog. He was always.
He just keep his final plea open, given that his counsel wasn't present today?
Yes. Let me see. Okay, next is State versus McMullen.
Morning, Judge.
Come on. If you, yes, please.
Please. Good morning, Judge. Attorney Lim here for Mr. McMullen. I don't have discovery yet. I am going to get it in different phases, but as soon as I get it, I'll do my best to get this case ready for trial.
You were just recently appointed.
Yes, Your Honor.
Did you not? Well, that's what I'm saying we're dealing with. I guess we'll hold this one open as well to allow. Let me see, what do we got for? Okay. All right, Mr. Lim. Then we'll leave it open and you can continue to come up to speed.
Yes, Your Honor. May I be excused?
Yes, sir.
Judge, can we get him to stay and spell his name for me, please?
Yes, M-E-N-G, last name L-I-M.
Thank you.
Thank you, Your Honor.
Yes, sir. Jarvis Bradford.
Good morning, Your Honor.
Good morning.
Attorney Aisha Braddock for Mr. Bradford. An offer has been conveyed by the state, and Mr. Bradford is rejecting the offer at this time, and we would like to be further notice to trial.
All right.
Thank you.
Further notice to trial calendar. Okay, now we're on Mr. Cobb.
Good morning again, Your Honor. As mentioned, I'm Attorney Kareem Cashlin. I was recently appointed on the case not even a month ago. I've yet to receive discovery. Additionally, I have yet to receive a plea offer for my client to even convey to him. And critically, Your Honor, unfortunately, I have been unable to get in contact with my client. I don't believe he is necessarily absconded from the court's jurisdiction. I believe it's more of a clerical error in that the conflict office has not given me the proper contact information. So I'll have to go to the clerk and ascertain that info for him.
Your Honor, Mr. Cobb has yet to be arrested on the warrant. In this case, Your Honor, he has not been arrested. So that's probably why there is no address for him, because he hasn't been arrested.
Right. Yes, he's been, my understanding, since we started, he's not, he hadn't been in custody, and his whereabouts are unknown at this particular point in time.
Yes, Your Honor, he's the last defendant that has not been arrested.
And I have seen in his history on Odyssey that he might have been returned to Washington State Prison. I checked their database, and he's not an inmate located there.
I don't believe, we aren't showing that Mr. Cobb is in custody anywhere else, are we?
Correct. No.
No, Your Honor, not at this time, no.
All right, well, unless and until he's before the court, then there's nothing we can do about Mr. Cobb's case. I would just say, stay ready. If he's brought into custody or whatever, then you start from there.
Will do, Your Honor. May I be excused?
Yes, sir. Have a good day.
Thank you, you too.
But, oh, you did make a official entry of appearance, have you not? Okay, thank you. Mr. Mender?
Good morning, Your Honor. Nicole Fagan on behalf of Mr. Mender. He has been relayed a message. He is rejecting the plea at this time for the notice of trial calendar.
Okay. Ms. Jones, did you get that? No, I'm the court reporter. I was just making sure she got, I know who you are, ma'am.
Yes, Judge.
All right. Then we'll further notice the case to the trial calendar.
Thanks, Judge.
All right. And next will be Mr. Winfrey, but I don't see Mr. Francis. Oh. All right, Mr. Francis has filed a leave of absence, and he's out of the country currently, and so. Yeah, briefly, go ahead.
On the record, I'd like to fire that counsel that he had legally corresponded with me no type of way with this case. If you saying this is the final plea, and I ain't had one lawyer visit, I ain't even got my discovery pack. So I would like to retain another counsel because I feel like I have been ineffective. Counsel by the way, Mr. Francis, I don't see no time. Never with court, never met with him, never answered the phone, and I understand that we've been since I do have a right.
Yes, sir, that's true. Are you asking to be able to get someone else appointed, or are you saying that you have the resources or intend to hire private counsel?
I can hire a private counsel, you can retain another. I'd like to be appointed another counsel.
Okay, well, let me make sure we're on the same wavelength. What I'm asking is, our understanding was that you were indigent and not able to afford to hire an attorney. Okay, well, then the question isn't whether you can hire a private counsel or get someone appointed. It would be either you end up having to stay with Mr. Francis or you're able to get someone else. I understand what you're asking, and we'll take that up at a later date because we need to have him here to be able to hear from Mr. Francis. Because he didn't, I guess he got appointed right before the last time we were in court. Was that not? I'm not arguing with you. Sir, I'm not disputing what you're saying right now, okay? I'm just saying I need to have him here so we can know the reason why if he hasn't been able to contact you or go forward with you. And unless and until we find out, we're not going to just give you another lawyer.
Well, I have my family retained when I want to.
Well, you're free to do that at any time. You're free to do that.
I'm doing it now on the record. I don't want him as my attorney.
Okay, I hear you. And I just said I'm not going to deal with that until we have an opportunity to have the attorney present. Okay, I got you loud and clear, sir. Okay. Okay, so Mr. Winfrey's remains open, which we would do because counsel isn't here anyway. And if we need to make a change, the court will look into that matter as to whether or not there's a justification for doing that or not. And in the meantime, Mr. Winfrey, if your family wants to hire counsel, then they're free to do that. There's nothing but air and between them doing that, but air and opportunity. And the air ain't gonna stop.
Drink. Okay, so yeah, a lot of much to do about nothing. As much as I would love for it to be, oh, that was so phenomenal. It's okay, yeah. And a lot of trial is that way. Trial can be very much boring, depending on who you are. You have to really love the law to love some of the developments. But basically, the most interesting part about this is those who did not have counsel were able to keep their plea deal open because counsel wasn't available. So I appreciate that the defendant said, Your Honor, I need to deal with this with you. Not only is my counselor not here today, my counselor has not been, and consequently, I cannot enter a plea deal because I don't know. You know, I don't know. I need to talk to my counselor. They're supposed to give me guidance. I mean, my counselor, I need to speak to my counsel, because my counsel is supposed to give me guidance relative to these issues. So I'm glad that they spoke up, even though he got reprimanded originally, but that got all taken care of in the end. Very, very odd. Very, very odd. Very odd for the very odd for the judge to be very defiant and definitive that you have to have your you have to either accept or not accept the plea deal today, right now, and even if your counselor is not there, if your attorney's not there. I don't understand. Because one of the things I would ask is, when they deny their plea deal, or if they were to deny the plea deal, how often have you talked to your counselor or your attorney about this? Have you sought counsel on it? You know, did you guys go over this? Don't tell me what was said, but did you go over it? How many times did you guys go over it? Do you understand that this plea deal says this? Okay, fine. But, you know, anyway, not too much going on. Seems like that hard day is actually a little flexible for those who didn't have the chance to speak with counsel. So they will have that later. This is not Young Thug's case. This is seemingly the next set of defendants, or additional set of defendants. They have 20 some odd different defendants. So they're going to have these type of pretrial motions and pretrial hearings a great deal of time. Interesting enough, so far Ms. Hilton is the only is the consistent prosecutor. So maybe the whole set is going to consistently prosecute each set of defendants. That's a lot of work for one set of people. And it'd probably be better suited if they actually had some other prosecutors to help. Not to say that she doesn't have a team, but it just seems like the same team for all of these 28 different defendants is a lot. Anyway, that's what it is. That's what happens. Did you learn something? I learned something. Speak up for yourself, even if you're going to get yelled at. Just speak up for yourself, because you have a very salient argument there, dear defendant, who said, I have not spoken to my defense counselor. I don't know who he is. I've never seen him, and I can't put in a plea deal or not put in a plea deal because I don't have advice from my attorney. So I am without counsel in effect. I appreciate that. All right, Lyric Armstrong, your real estate agent and advocate. See you in the next video.